क्रिप्टो उत्पादों NFTs अनियमित हैं और अत्यधिक जोखिम भरे हो सकते हैं। ये संभव है कि इस तरह के लेनदेन से हुए किसी भी नुकसान के लिए नियामक सहारा प्राप्त ना हो।
Hello, everyone. Good evening to this YouTube live session organized between CoinDCX and the Elite Web3 Forum. Today, we have a very, very important discussion about data protection, particularly relevant to the new data protection bill that's come out really recently. But apart from that, this will be an important and larger discussion about how data protection and privacy will actually work in an era of immutable blockchains. So to discuss this rather technical topic, we've got three experts. Mr. Jayjit Biswas, who's the founder of the Elite Web3 Forum, will be moderating this conversation. Mr. Rohit Shrivastwa, who's an expert in the field of cybersecurity and privacy, and also the author of the book, My Data, My Privacy, My Choice. And finally, Mr. Sharat Chandra, who's a leading voice in our industry and the founder of the India Blockchain Forum. Jayjit, I'll give the floor to you.
Thanks, Zitiman, for nice introduction. And obviously, we are coming between the income tax filing date, which all the crypto lovers are busy. But still, the data privacy bill is a hot topic to come and will be passed in the monsoon session of Parliament, hopefully, because it is already due for the cabinet has already cleared this bill with some changes, and hopefully this bill will come very soon in the Parliament as an enacted forum. Only thing I like to share, because crypto, blockchain, and Web3 is a global phenomena, the GDPR already has been there for European Union, and other data protection act in the world are already in vogue. India still figuring out what is privacy, what is the definition of privacy, and initially they had a long bill, but it cut down to a very precise form now and been passed by the cabinet. Ministry is over there, but it is yet to be passed in the Lok Sabha and Rajya Sabha. So it will be placed in the monsoon bill. But in the opening remarks, I try to see, Zitiman already talked about the immutability of blockchain, cross-border nature of blockchain and Web3 applications, and how data privacy bill itself talks about data erasing, data localization versus blockchain talks about data globalization. These are the nuances we will talk about. There are some conflicting zones between privacy per se and blockchain and a Web3 application. But we need to understand how Web2 and Web3 is different. Web3, we are talking about own your own data, not by giving control. In Web2 era, we have given our control of data to the companies like Meta, Google, Amazon, and all to utilize our data in a Web2 space. But in Web3, what ethos of Web3 is decentralization, control of ownership of the data to us. So in that sphere, I will not take the much time to throw upon this insightful discussion. To start with Rohit, who is a privacy not only expert, he is generally practitioner of privacy. He can talk about what is in the privacy currently in the privacy bill per se, irrespective of Web2, Web1, and Web3. What is there currently to give a layman's briefing of that privacy bill? Rohit, can you take it up?
Hey, thanks, Jayjit. Thanks for having us here and in this interesting discussion at a very right time. And one most important thing, sorry, I'm not an expert in all of these areas. I'm still a student trying to learn all of these and make sense for myself and people around me in the world. That has been my effort on this line on data privacy and other related aspects. I was closely associated with a lot of people who were working on this bill, and a lot of activity has gone inside. Uh, when we started this whole conversation about data privacy bill, the DPDP, or Initially it called as DPD, then called as PDP, and then finally DPDP as the bill itself. A lot of work has gone inside it, and one thing which I personally feel is when you deliberate too much and start doing a nitpicking, a lot of things get diluted out, and which has been visible right now. But again, let's quickly take a overlook of what the whole bill is and what is it all about. uh, Few very important aspects about this is the power is being given to the people, that how your data can be utilized, and you need to know, or the companies who are actually using your data need to tell you how are they going to use your data. And consent, it has to be taken from you, that okay, we as a company, as an organization trying to use your data for these purposes, is it allowed from your side? And then you have to give a deliberate consent to that, that okay, please use my data, or basically the private data, for this kind of use cases. Interestingly, this bill also gives a right to the user, or the, and so I would try to avoid the technical words here like fiduciary and the DPA and authorities. But you and me as an end user, we have this right that okay, if my data is being used, being collected by someone, suppose let's take an example of a e-commerce website. If they have collected our data and they are using it for maybe shipping the product to us, or doing any kind of analysis which they do on their app, tomorrow if I decide that okay, I'm not going to use this website anymore, and I request the organization that delete my data, the bill actually gives me a right to be forgotten. My data has to be erased from the end user or the owner of that particular, or the processor of that data, like the e-commerce website in that particular case. This is a very powerful thing. People do not understand the value of this, because a lot of people which we have seen, people do not understand the value of their own data. There have been cases that people have been happily open to give away their private data, a lot of personally identifiable data, in return of a gift coupon, or in return of a probability of a winning a cruise trip to somewhere, and all of those lures. And level of awareness is now coming up in people with this whole debate around the DPDP as well, that okay, your data is important, it's private to you, and how do you manage it? So in the era of web 2, we have seen and as you rightly pointed, a lot of organizations collected a lot of data which was not even needed, and then used that kind of data to understand our habits, our behavior, the way we go, the way we travel, the way we eat, the way we shop, and a lot of information. So that accordingly, their services can be offered, which we may or may not want, or which we may or may not have consented to. Which will become very easy now. The consent will be very clear that okay, I want you to use my data for this, so that people are aware. They are told that what is it be used for. And then interestingly, this will be applying for both government and private entities as well. Now, when it comes to this, the most important aspect remains is people will have to start understanding what does it mean. What does it mean when my data is out, or what are the harms which can be caused? So the effort to that, and effort to make people aware. I wrote this book, and this was published during the initial COVID days when everybody was at home. And the idea of the book was same, to make people understand what is the need of data privacy. How can you see what kind of data is getting leaked out on internet about you, knowingly or unknowingly, and how can you protect that kind of data? Now we are moving from that place to the world of web 3, where it's a uh, very good to see environment, that okay, the data would be owned by the user, and then the central organizations will not be owning the data, the users will have all the rights. I'm a little skeptical of the difference between theory and practical there. In theory it sounds very good. In practical, what we see that even in that case, larger companies would be the central places where the data would be still logged in, and you would need to know that how that data is being maintained. Even if you look at the recent regulatory requirement for the crypto exchanges in India, and the users, the KYC norm, the different taxation issues which we have seen in past, the information of that particular user will have to be there at the end of the body who's maintaining the crypto exchanges, CoinDCX alike. So then again, the data is somewhere centralized. When I take that, keep that data purely on the central exchange and try to keep it secure and go on to the blockchain, maybe Sharat would be able to put the right light on that. But those data, when those transactions are happening with least knowledge, I would be happy to see that there's less of identifiable data going on to the chain. Only the transactional data is going on to the chain. But yes, this becomes a responsibility of any organization, may it be a metaverse company, may it be a crypto exchange, or maybe anyone, a DApp or different central applications as well, that you are maintaining the data very safely, securely, and following the requirements of the new act. One thing which I'm really worried about is this is going to be a burden or cost to the people, or rather to the organizations who are going to set this unit. So suppose if I am running a company and I have data collected at my place and I'm going to use that data, there would be a overburden on me. The cost of doing business, the cost of compliance will increase, and will have to maintain that. But again, if you're trying to do business with those kind of data and aspect, you must be ready for those kind of costs as also. That's in brief what I can talk about the privacy and the upcoming bill and stuff. We'll be happy to take questions further if required.
Okay. Thanks, Rohit. You touched upon the gap between what is spoke theoretically about Web3 and what is actual practice. Yesterday, we have seen Amazon has launched Amazon Managed Services for blockchain and Web3. So big players, like many big players are coming. Even BlackRock ETF is already there in crypto market as a big player for in and we have heard they have entering into India with Geo Financial Services, and who knows that in coming days Indian entity also in the crypto or ETF markets. So in that note, I try to put the ball in Sharat's court to give us the nuances of blockchain and what are the conflicting areas in relation to blockchain and Web3 application. Blockchain application already done. What are going to happen after privacy bill coming in? Because blockchain and Web3 as a global phenomena already encountered the GDPR regulation in Europe and other regulations. So the Indian data privacy bill is not new to the player like Polygon and other application developer, Ethereum and all those stuff who are developing the blockchain solution. And I will try to get some brief because you are associated with Telangana Sandbox and government projects, Sharat, as the Indian Blockchain Forum. We try to understand how as the industry see this privacy bill impact on the blockchain application per se. Over to you, Sharat.
Thanks, Jayjit, for the question. Good evening, everyone. So let me begin by the positives first. So this bill is a lucid one and I would say clear and transparent one and complete departure from the GDPR orientation. If you look at the previous versions of the bill, they were, I would say, a mimic of or maybe a replica of GDPR, or they had some flavor of GDPR. So this is like India coming on its own and framing a policy which is more India-specific or India-centric. So this is also a principle-based regulation and sector agnostic. So what it means, it's tech neutral. So tech neutrality is at the core of this legislation. Now, I mean, if you go through the sections of the bill, there's on the page 16, it's 24-page draft which was published in December 2022. The page 16 talks about exemptions where the government may notify certain businesses which will be exempt from some of the provisions of this personal data protection bill. Now, the reason why all the industry experts and privacy experts, they're interpreting this as government's way of promoting responsible innovation so that startups or emerging companies, they are not burdened with the cost of compliance. So the bill has three main components. One is a data principle, people like you and me. The bill also calls data principle as digital nagriks, and data fiduciaries who are collecting data, right? So let's say big techs will be, or let's say the Web2 native companies who are collecting our data will be data fiduciaries. Even in data fiduciary, there's a two kind of demarcation. One is significant data fiduciary, that the big techs of the world, they have a bigger compliance burden to bear as compared to new age companies, startups for that matter, right? Now, so the government has drafted the bill in such a way that there's enough room for allowing people to experiment and allow responsible innovation so that startups are not burdened with the compliance cost. Now, coming back to the concept of blockchain, because blockchain by nature of technology itself, if any data gets stored on chain, is difficult to erase, right? So the right of erasure, which is there on the bill, will stand defeated if you look at the bill in that particular context. If I were to look at the 2019 version of the bill, so it had a clause for anonymization where any anonymized data will be exempted from the bill. So I think this particular clause is missing in this bill. So imagine a case where any blockchain native business is using anonymized data, right? Data in the form of cryptographically ensured form, then that data will be excluded if we were to go by the 2019 bill. But the current bill doesn't talk about anonymized data, and we have enough technologies like zero knowledge proof, which ensures security and anonymization of data, right? So it will get down to whether the government is open to including blockchain native companies as part of the exemptions they have on the page 16 of the bill. So under exemptions, I would strongly, maybe as a industry or community, we should strongly speak about making blockchain native businesses getting recognized as one of the entities under the exemptions section. Now, when it comes to the data transfer part, right, international data transfer, we all know blockchain is a decentralized technology. It recognizes no borders. So the bill says that personal data can be transferred to certain whitelisted nations. I mean, the list is yet to be prepared, and again, a lot will depend upon what is the reciprocal nature of data sharing is done by those countries. The way US and EU have a data sharing agreement, right? So I would still say that if we look at the exemption part and try and convince the regulators that blockchain native businesses can be included in that list, that will be I would say enabling the growth of business rather than restricting blockchain native businesses. So that's my 2 cents on this. Happy to take any questions.
So Sharat, if we as an industry get that, see, after this enactment, the rules will come up and process and procedure will be laid down. Apart from that exemption list yet to be finalized, which can be discussed along with NASCOM, MIT, Indian Blockchain Forum and other, along with BharatVerse Association and all, to give, because majority of the crypto exchanges and exchange, these are private limited companies, not listed companies under SEBI. Not big tech like Web 2.0 or 2.5. All Web 3 companies zone, very, very new to the industry, like 1 and 2 year or 3 year old, not much of that. So can we, before building up the compliance cost, let us understand both the front. Web 3 is also an understanding phase. Web 3. And data privacy bill also new as an understanding the impact of privacy, where Rohit already touched upon that knowingly, unknowingly, we have already given many data already, which may come up as an inheritance from Web 2 to Web 3 industry. Because many players in Web 2 are migrating to their Web 3 business. I am giving you one classic case like Opera browser. Opera browser are coming in Web 3. Now, one of the Twitter spaces, I asked this question to Sandy also, that whether the data already collected by Opera browser version, in Web 2 version, will they commercialize the same in Web 3 and use the same, and whether they will take the fresh consent from the user or not, or whether they will already the consent taken willingly or unknowingly by the user can be used in the new era. So my question to both of you, Rohit and Sharat, that understanding this, there are people already in this segment industry, whether they are again need to go up to get the new consent from the users about asking the definitive what are they will do about collecting this data, PII data, personally identifiable data, whether they need to collect reconsent or new consent, or whether they can use the earlier consent taken before the bill. What will be the process, Rohit? What is according to you? Whether consent again need to be taken?
One thing is very clear that yes, reconsenting has to be done. The organizations will ask that, okay, this is as per the new act. Remember GDPR, the moment GDPR came in, every website started showing up a cookie notification on the website and started taking consent again. So similarly, a lot of organizations who already have data will start taking consent. Problem is not that. The problem is the consent would be so legally worded that a common person like you and me, when they go to the website, it's like, oh, some terms and conditions somewhere has changed to make sure that I continue using the website, and there would be one accept button. In last so many years, multiple decades, we have never read a end user licensing agreement or a contract which is coming online. We do expect that people will be reading this change and taking an action accordingly, that what would be the use of my data and how the consent is taken. Practically no. So again, it is an easy part that, okay, can the reconsent be happen? Yes. Will the reconsenting be happen? Yes, it will happen. Will people be blindly giving the consent again? Yes, even that will happen.
So Sharat, before going to the role of a community in making the awareness part, I am coming later. Before going to that, you talked about data eraser, which is very difficult in blockchain to erase the data which is already on the chain. And then how right to forget clause, if I want to withdraw from anything and ask that my private data to be erased, or I want to opt for the right to forget clause, then is it really possible at this moment in the blockchain and Web3 forum, Web3 area application?
So a lot will depend upon where exactly is the personal identifiable data is being stored. If it's being stored on the user's device itself, so there are technologies which can allow you to store the PI information on the user device, and a data fiduciary or anyone who's interacting with the data is not looking at, is not storing your data, right? So that is one. So if you're storing data off the chain, let's say on the user device, then the user itself will be able to modify, change, delete whatever he or she wishes to, right? But if, and we all agree that personal PI data should not be stored on the chain, right? Only transaction data or necessary data, or maybe anonymized data or synthetic data should be stored on the chain, right? Now, if let me go back to the bill again, because the bill also talks about the concept of a consent manager, right? Which a data fiduciary should be using to allow data processors who should be processing the data. So if you look at this particular aspect, this will also give rise to new set of businesses or products or tools which can allow both individuals and data fiduciary companies to allow people to share their data in a seamless and secure manner. The concept of consent managers. So imagine the case of new cottage industry of consent managers picking up in a big way, right? And with technology solutions at our disposal, right? With decentralized identities, we can anyways create these solutions, right? And Polygon has already set the ball rolling, and because they have made their entire ID solution open source, right? So I think consent managers and companies or fintech companies who can build something like consent manager as a service, right? So that people can start incorporating these solutions will be a big positive. I would also like to highlight one news which came in Economic Times, I think 3 or 4 days ago, where it was stated that the draft will have a segment or a clause which will do away with continuous consent, so that once you are given the consent, that should not be a deemed consent for data usage till eternity, right? Every time the data fiduciary wants to process your data, then the data principal or the user needs to be informed. Okay, this has to be itemized constant. Okay, this is I'll be using this particular data or these elements of data for so and so purpose, right? And this is where decentralized technologies will have a bigger role to play. So I'm looking at the regulation. Yeah.
So Sharat and Rohit, in the context of decentralized Web3 blockchain and all, we talked about decentralization so much. Who will be acting as a data fiduciary in the gamut of blockchain, or where there is no central custody, a central organization working on behalf or in whatever we have seen in Web2? It is a very first question when Ditiman spoke to me about this topic. The first question came to my mind is that who will be the data fiduciary or a data custodial in the blockchain gamut, in a Web3 gamut? Can you both give a little bit of highlight? Because you already talked about managed organization, managed services by someone on someone's behalf. So that type of solution may come up as a people will start working as a bridge between you and Web3 player to collect your PII data as a managed service, which you talked about just now. So please elaborate on that piece, because people will like to understand this intricacy.
Right. So let's take an example of a digital asset exchange, because any which ways when they are onboarding users, they are doing KYC, and as per BAT's notification last year, they're supposed to store KYC and transaction data for 5 years. So they are, by that definition, already a data fiduciary, right? They're storing, collecting, and storing customers' data. Now, to enable a seamless consent, because every time they need to process that data, they need to seek consent from the users, right? And that's where these bridging solutions like managed service consent managers will come into play. So they will just act as a channel or a conduit. They will not be processing the data. They will be handing over the data to the data fiduciary, and the entity will be able to decide how they want to process it. That's how I interpret this this bill. But Rohit, open to your thoughts and suggestions.
Thanks, sir. Jayjit, one important aspect. It's a technology. Call it Web 1, Web 2, Web 3. Ultimately, it's a ICT technology where you need a computer, you need a resource where it is working. Bring it onto blockchain. Okay, the whole infrastructure is mixed and open and nobody is owning that. I agree to that part. As Sharat very rightly said, to get to use the blockchain, there would be some intermediary in between. To support blockchain, AWS is coming up with a managed service. To run IPFS, the absolute open file system and everything where nobody is owning the data, again, you need some player who would actually keep it on somebody's laptop, desktop, server. There are intermediaries. So if in this particular case, suppose let's go on a practical level, I go ahead, create a mechanism. I will not use the word wallet. I'll create one mechanism to access the blockchain. And let's talk about the Ethereum blockchain, and do a transaction between me and Sharat, me and you and Sharat do some transaction directly one-on-one. Whose data are we talking about? And if there is a private data involved, suppose I write on that particular channel, the chain, information that, okay, Rohit and Jayjit this, Rohit and Sharat this. I am the one who is doing the processing and putting it onto the chain. So I am the fiduciary, and I, and along with you, are the data subjects. But when it comes to any practical uses, so this is the theoretical use case where all of us are directly accessing the chain and doing something. Even in that case, we who is actually keying in on that keyboard, it becomes the data fiduciary because you are acting on it. When it comes to the regular use case of Web3, like any exchange or any swap place or any DApp for that matter, they become the data fiduciary in that case, because they are acting on your behalf by taking consent, by you signing the transaction. They are acting on your behalf to put that bits and bytes onto the blockchain. It's not you who's directly doing it. So that's where the fiduciary will come in. And believe me, when it comes to the execution or bringing this act to the real ground activity, people will figure out these methods that, okay, if something of this is happening, who is the actual fiduciary in that particular case? Theoretically, very well possible that, okay, there is no data fiduciary and it is all happening directly. But there are people who are in the center point who are executing.
Yes, I exactly try to echo the same, that to me at least, at this moment, the development, Web3 or blockchain, calling it fully decentralized is a myth at this moment. There will be some intermediaries or infrastructure player or somebody from the Web2 world migrating to Web3. Name may change, but it may old wine in a new bottle. So some portion of it may be a hybrid scenario, decentralized per se at the front end, but back end some centralized player will be there. Even we know Ethereum, 66% of Ethereum is controlled by some group of people. Even it was doubted for Bitcoin also. So there is a conduit also between the centralized ownership and the decentralized ownership, which is yet to evolve. People are very happy to say that we are decentralized, but yet it is in a back. We know the people who are already on thick and thin of this thing. We know that what is actually in the reality. My next question is that whether I am directly coming the people's question with some burning question. Will MetaMask wallet IP address will be considered as a PII data? A question to both of you.
One word answer, yes.
Yeah.
Sharat, what is?
Agree. Because I mean, any information which can be tied down to individual can be considered as a PII data. It can be your location data. It can be your vehicle data as well, right? It doesn't have to be your name or date of
So
birth.
what I understand that if your MetaMask data is connected to your any bank account or any PII data, it will be considered as a PII data. But
Yes.
if it is not, if you have multiple MetaMask or multiple wallet without linking with KYC, it can impact as anonymity, or it may not be called as PII data because you are willfully having created multiple digital identity or a wallet which may not be linked to KYC, which is not proper at this moment.
No, Jayjit. The point is, look at IP address. You may have a KYC wallet or non-KYC wallet. Your IP address is basically a temporary
Okay.
object assigned to you by your
In the
telecom
internet.
provider, and your telecom provider knows at that point of time that at this particular time who is the subscriber of the service.
Okay.
Go back to your web 2, web 1, and even all the crime investigation and other stuff. How does the crime investigation happen? You get to know the IP address, then you talk to the ISP that on this particular date from this time to this time who was using this IP address, and that's how you reach people's home, and that's how the whole crime investigation happened across the globe. So it is an identifiable piece of information. Using that, somebody can reach your place. So it could be a KYC wallet, non-KYC wallet. That's a separate story. Now, if you are anonymizing your IP using all the different methods the criminals use these days by proxies and bulletproof hostings and different VPNs and other stuff, you are still moving that risk away from you. As an attacker, you're moving that risk away from you, but there's still traces which can be connected back. When it comes to the KYC wallet, it's all one-on-one connected and informed. So as I said in the last example, if I want to do some transaction between you and me, both of us can go ahead on a chain, create a wallet, MetaMask or Phantom or anything, and then do the transaction. Is it 100% anonymous? No, because the IP addresses can be traced back. So for me,
and Rohit, one beautiful thing of blockchain that everything is traceable in blockchain.
It is.
And ultimately it can link to you final destination. So ultimately it will qualify as a PII data in spite of buzz in the normal layman's word in Web3 that whether my wallet is a wallet ID is a PII data or not. So that is rest assured. Now I am coming to Sharat. Sharat, if the crypto exchanges in India comes under the purview of new act or new bill, what type of compliance cost or additional compliance they need to follow? That is because we are associating with CoinDCX for partnering this show. They are also eager to know what additional we need to follow after this bill.
Right. So since the bill talks about two kinds of data fiduciary, and one is a significant data fiduciaries, any entity which can have the kind of and the quality of data which a data fiduciary is processing, right? That will also attract compliance provisions. And so the government will notify in due course of time what are some of the roles a significant data fiduciary needs to have or function. For example, the bill says that they need to have proper audit, they need to have a data protection officer, something like a nodal officer, somebody whom people can reach out to in case of a grievance. So these are some of the added costs, right? Which exchanges will anyways have to bear because they will be processing significant amounts of financial data. So I'm interpreting that exchanges or even social media companies, they will fall under the category of significant data fiduciary, SDFs. So by that definition, there will be a significant compliance cost in terms of audit and in terms of data storage, because even KYC data has to be stored for 5 years, right? Similarly, the cost of appointing a nodal officer or a grievance officer. So these things will be adding more to the existing compliance costs.
And
Thanks,
not only
sir.
on the compliance from the people perspective, even the tech perspective, there will be a lot of expenses added
Yes,
on top of
security
to secure the
and
data,
all.
to take care of the even data searching and erasal of data and those information. It requires a lot of tech effort as well.
So Rohit and Sharat, my next question is, forget about crypto exchanges. In Web3, we are talking about fintech. Many banking institutions are collecting so many personal data and moving into fintech area. Rohit, you are a founder of BharatVerse, means the Metaverse. Many banks, many corporates are venturing into Metaverse, where digital twin avatars and digital identities will come up. How you see what is the impact of this data privacy bill on Metaverse front, at least?
It would be an interesting play to see that how see anybody who is trying to do a Web3 project is trying to see that, okay, can I have minimal amount of data and still operate? But then there are regulatory requirements of KYC and other aspect, and very well captured by Sharat at that point of time. There would be intermediaries whose work is this. Like there are KYC intermediaries these days who maintain the KYC, and the end customer versus end service provider are working on their main core tech. Those kind of efforts would increase for such, and again for all good reasons. And I always say this, that the privacy is not above national security. So for all of those such reasons, there would be a lot of identifiability available in metaverses and other places as well. You cannot have feeling that, okay, you are really anonymous on a metaverse and place like that, and then can go ahead and commit a different kind of a crime. So that anonymity, I would suggest people, even if they have this belief in their mind that with full-fledged Web3 we will go full anonymous, please don't have that, because that's not going to happen anytime. Again, when it comes to the data capture and collection, it has become a similar pandemic in last multiple years, that people love to collect data from everyone. And okay, I don't have a use right now, but let me still collect the data. I may have a use case of this data in future. And there was a very popular saying that data is the new oil, and everybody started hoarding the data, then we will make more money out of data. With GDPR, I came out with one statement, which I would say even now with DPDP: don't consider data as a new oil. The data is the new radioactive material. The less you capture, the less you hoard, and the less amount of time you hold it with you is the safest thing you can do, because it is a radioactive material. It's no longer an oil.
Okay, Rohit, with the paucity of time, we'll take up this conversation after the bill is enacted. But I am trying to give a note to my all viewers that they must be already know WorldCoin has been launched based on the iris data of the user to make a digital identity of the internet. Digital identity, like their Aadhaar card may be applicable to India, but iris scan or the Sam Altman is trying to give at the in digital identity at the internet, global internet, and converting that as a $20 coin. And yes, up to yesterday, 20 lakh people, 2 million people already enrolled for WorldCoin app and thing. So with this, whether this will create another buzz on privacy, they are taking a iris and all. These are yet. But over to you, Dhritiman, because we are in the fact end of the conversation. We may need a second round after the enactment of that. Over to you, Dhritiman.
We should have that soon, once the bill is converted to act. And I'll just add one statement before we move on. I remember there was a research long ago that people data worth is of $12, and which they don't pay and give all of that data free of cost to social media companies. I'm happy to see that our value of data has increased from $12 to $20 now.
Thank you. So our credit card information is sold at dark web at ₹7 only, apart from medical data. So Dhritiman, over to you for giving us the opportunity to discuss on this hot topic, both Web3 and privacy.
So thank you, Jayjit and Rohit and Sharat, for a fantastic conversation here. I don't know if people give enough importance to these laws and how they're going to affect them going in the future. But I think this, hopefully our listeners now realize that this is going to be very important. Whether you're talking about Web3 or you're talking about any sort of digital service or intermediary. With that, thank you guys so much for coming on. I don't need to drone on anymore after this fantastic conversation that you guys put on. So thank you all for coming on, and thank you viewers for listening in. And we definitely hope to see you next time as well.
Thanks a lot.
Have a very privacy safe, happy world.
क्रिप्टो उत्पादों NFTs अनियमित हैं और अत्यधिक जोखिम भरे हो सकते हैं। ये संभव है कि इस तरह के लेनदेन से हुए किसी भी नुकसान के लिए नियामक सहारा प्राप्त ना हो।